Tom Abbate with Parnham and Associates again, and I'm here today to talk to you about the new House Bill 1325. This is the new marijuana law that defines what is marijuana versus what is hemp. And under this new law, in order for a substance, and this can be leafy green, this can be oils, this can be candy, anything, any kind of substance that is alleged to contain THC will not be deemed to be marijuana unless the total amount of THC in the substance is greater than or equal to 0.3% of the entire substance. Meaning if you've got 10 grams of a substance, 0.3% of those 10 grams has to be THC. Anything less than that, and it will be considered hemp, and it will therefore be legal. This will cover CBD oil, any kind of non-THC product that can be purchased at any kind of health food or stores of that nature. Now, this new change is creating some potential problems for the state in securing marijuana convictions because the 13 DPS labs, as well as all the private labs in the state of Texas, are not set up to run this kind of a test. The old manner of doing it was to simply test the substance to determine whether or not there was any THC in that substance at all. If there was, it was marijuana and it was illegal. If there wasn't, it was not illegal. Now it's a little bit more difficult, and they're just not set up to run this kind of testing. So it's going to affect the state's ability to secure a marijuana conviction against someone because most defense attorneys are going to go in there at trial and ask the toxicologist whether or not they believe that this substance is marijuana. If they do believe that it's marijuana, they're going to ask them whether or not they tested it. They're going to say, we didn't. And so therefore they don't really know what the substance is under this new law. However, there's already some talk among some of the DAs in this state about ways to deal with this. Some have referenced that this is essentially an affirmative defense, and it's going to be on the defendant to offer evidence and prove that the substance contained less than 0.3% THC. This is not entirely true, though. What it is that the state is going to have to prove its elements, and one of those elements is that the substance is in fact marijuana. They can do this in a couple of different ways. The easiest would be to run the testing, but no one's set up for that, and it's pretty expensive, so they're probably not going to go to that route. What they're more likely to do is try and get some circumstantial evidence that will help to solidify that this is marijuana. And this is why it's very important that you know your rights. About 90% of all marijuana busts occur in an automobile. It's not advisable to be smoking in your car or consuming any kind of narcotic for that matter while you're driving down a road. However, this is just generally where it happens. And so if you're stopped by law enforcement and they are investigating you for possession of marijuana, let's say they search your car and they find some, probably one of the most common questions they're going to ask you is, what is this? If you say this is marijuana or this is pot, that evidence is definitely going to be used against you at a trial later on, and it may very well help to solidify that the substance that you possess was marijuana. Now, you don't have to answer their questions, though. You always have your Fifth Amendment right, and anytime a law enforcement officer is investigating you, it is advisable to stand on those rights. It's very simple. Just when the officer asks you some questions, just very politely tell him, "Officer, I'm not going to answer any of your questions without my attorney present." Or, "Officer, I'm going to engage my Fifth Amendment right to silence." or just simply say, I'm not answering any of your questions. Any of them will work. Just hold to it and be professional. Be polite. He's trying to do his job. You don't want to make the situation worse by being rude or nasty, and it's really unnecessary to begin with. So just politely tell him, officer, I'm not going to answer any of your questions. If they arrest you, they're not really going to be able to prove that it's marijuana unless they do the testing at that point. And so that's going to help you to keep that marijuana conviction potentially off your record.